And today, the NSA's most controversial program heading to a high court in D.C. Under the program in question, the agency collects metadata and content from people's phone calls, including their frequency, the numbers dialed, and even the length of conversations. NSA supporters call it an effective way to find terrorists. But will the Circuit Court of Appeals find it a violation of your privacy? Let's ask Fox News senior judicial analyst Judge Andrew Napolitano. He joins us this morning with this important question. Good morning, Judge. So many people feel this is a violation of their privacy, that this is government overreaching. What does the law say?
Well, we start with the Constitution that says when the government wants private information about anybody, it has to follow the Fourth Amendment, which says only a warrant issued by a judge based on probable cause of crime, quote, particularly describing the place to be searched or the person or thing to be seized, close quote, can validate the invasion of privacy. In this case, the NSA goes to a secret court and the court says, here's a piece of paper. It's a general warrant. Look wherever you want and seize whatever you find. The question is that kind of a general warrant as opposed to a specific one, identifying what they want and based on probable cause, naming the target as the Constitution requires, is the general warrant legal? 3 federal judges have looked at this. 2 have said it is legal because these are difficult times and we face a difficult and elusive enemy. 1 has said the Constitution is paramount. It's always paramount. The government has to find a better and more constitutional way to protect us. That judge, Judge Richard Leon, an appointee of President George W. Bush, is the one whose decision is being appealed today. Ultimately, you know this perhaps better than I, this will make its way to the Supreme Court. Because when judges differ and then appellate courts differ, then the Constitution means different things in different parts of the country, and that's not good.
And we can't have uniformity for the citizens. We have to have some kind of direct decision on this so people know where we stand on it.
Correct. Now, the government argues that the Fourth Amendment only pertains to criminal prosecutions. And as long as the evidence it gathers from listening to all our phone calls and reading all of our emails and looking at all of our bank statements and credit card bills and utility bills, as long as it doesn't use that as evidence of a crime in a criminal prosecution against us, it's okay. Judge Leon says the Constitution applies to everything the government does, whether it's intelligence gathering or its own curiosity or criminal prosecution.
And the point is to protect the citizens from this intrusive and unlawful invasion into their privacy. Now, prior to 9/11, I think this would have been a settled question.
Yes.
They're really kind of bootstrapping it onto that to say, in fact, because of recent terrorist activities, you refer to an elusive enemy, that this is necessary to protect the citizens of the United States. Therefore, they don't take the direct interpretation of the Constitution.
Kimberly, you must have read these opinions.
Yes.
Because the 2 federal judges that upheld this, whose decisions are not being appealed today, one was appealed already in New York, the other will be appealed later this year in San Francisco, said exactly what you did, and that is the government's argument. The Judge Leon argument is our privacy is a natural right. It's part of our humanity, and the government can't take it away by fiat or majority vote. And the Congress is also being spied on because they didn't authorize this.
Okay. And the question is, we want to make sure that we're safe, that we get the information, but we do it in a lawful way.